You'll find the paragraphs in the answering affidavit starting from page 225 from paragraph 52 and refers to NM6. My Lord, you'll recall is that document in regarding the deployment to Alexandra, and you were referred to the military language and combating the enemy, which is COVID-19 and so forth. But I'm only referring to the guideline that's relevant, and my Lord will find that at page 227, under paragraph 37, in the middle of the page, the heading is misleading, quite rightly, says use of a firearm. But my Lord, one doesn't just look at the heading. The SAPS says it has trained the members of the SAPS on the matters that are covered in this guideline. One goes into the content and see whether it's talking about arrest. It says,
I forgot to ask, when did these guidelines come into operation?
This was issued before the, you'll see, my Lord, at page 291, it's got a date, 30 March 2020. That would be in relation to the deployment for this Charlie company to Alexandra. But the SAPS explains that this are issued to the particular platoons. Can I just to Charlie company in this particular the battalion in this particular case would be issued with this. But this is preceded by training on these issues, and that is described in NM9, which I'll come back to, which is under the guidance of the legal division of the SANDF about what the deployment is about, how they are meant to interact with the SAPS. And 227, my Lord, that paragraph B says, the present section 49.2 of the Criminal Procedure Act determines that if any person is authorized under the Criminal Procedure Act to arrest another, attempts to arrest such person and such person resist the attempt or flees, and the person cannot be arrested without the use of force, the person so authorized may, in order to effect the arrest, use such force as may in the circumstances be reasonably necessary to overcome the resistance or to prevent the person concerned from fleeing. Then they are referred to an SEA test, my Lord, on how the SEA will determine whether you were justified in those circumstances to use force. And given that they are, and then the further part at page 228 deals with whether you can shoot, you can give warning shots and the likes. But the point is, it's difficult to understand what guideline they envisage than telling them that if the circumstances warrant, given this step that is applied by the SCA, you are entitled to use force, but otherwise you mustn't. That you must now enumerate, I don't know, 50, 100 different situations in which force may be required or force may not be required. We submit that that's, even if you gave it to lawyers to write these guidelines, they probably leave the test as flexible as possible, because judgment must be made by the trained officer in the circumstances confronting that officer. And they're giving guidelines. That's the first one, my Lord. So the guideline is there. The second is the right to arrest, an alternative means of securing attendance at court. They say, well, the SNDF doesn't guide its members on this. My Lord, we deal with that in our heads of argument, and I'll give the correct page number in a minute, as paginated. That would be page 106 of our heads of argument, my Lord. That's the second category of guidelines that they say are missing. And that is, when does an SNDF have a right to arrest, and how can you secure alternative means of attending court? My Lord, will see at paragraph 59.3, we actually quote from NM9. NM9 is at page 335 of the answering affidavit. I don't need to take, my Lord, the 339. Perhaps, my Lord, it might
339.
335. Might be useful to just look at it, because that.
But doesn't it say that it must be a crime committed in your presence?
Absolutely.
And handed over to the police?
Exactly that. That's the paragraph we quoted in our heads at page 106, my lord. Yeah, it's quite clear. And the Act also tells them that. I read the section in the Act that says the same thing. And then they say we don't have lockdown guidelines. But what the guidelines that they say, one must see what they're talking about in that paragraph when they say lockdown guidelines. They say we haven't provided guidelines about the enforcement of the lockdown regulations and any other regulations issued during the state of disaster, or guidelines about enforcing social distancing and the restriction of movement and other activities at each of the different stages of alert during the stage of disaster. Our answer to them is we don't lay the law on social distancing and movement and all of that as the police or the SANDF. We are given the law by the designated minister, who is the Minister of Cooperative Governance. They don't want that minister to produce any guidelines. They come to us. All we do is, one, that minister has said, a meter apart, or you shall not enter, not be served in a shopping mall unless you have a mask on. That's what we enforce. That's the law we enforce. How do we enforce it? By doing the things that we've been trained to do. Either if crime is committed in front of us, we can arrest, and so on. So it really doesn't make sense why it's expected.
When they talk about crime, what crime do they have in mind?
I suppose they might be, because they don't investigate crime, but they still assist in crime prevention.
I mean, if you don't wear a mask in a shopping mall,
that would not be a crime. Well, these are different other crimes, my lord.
Is that right?
Yeah, other crimes.
Now, I'm just worried. You know, I read an article somewhere that said we've now created 18,000 new criminals by who didn't obey some or other, rule. Yeah. And now they all have a criminal record which will affect their employment in future and so forth.
I think it's regulation 811 of those disaster management regulations, which creates offences in respect of certain things. But that's
just one thing. Why didn't they say, look, let's make it an administrative offence?
Yes.
And if a fine is imposed, that fine will go to the solidarity fund.
Yeah, we should advise them, my lord. They need advice to revise those things.
18,000 criminals. Some of them are young people when they apply for employment, or apply for a bursary, or apply for something in the future. Then they have a criminal record.
Yes, that's undesirable, but I suppose that's a matter of policy which hopefully
you as senior counsel have a lot of influence. Maybe you can make that
They probably went to other senior counsel, my lord.
No, but I mean all the senior counsel.
Yes, but I think the point is right.
Yeah.
Yes. So that those guidelines come from that minister, and we enforce them. That's what we can do. We can't create new guidelines now. They might conflict with those lockdown guidelines. Then they also want us to give them guidelines on information regarding where members of the public may lodge complaints against members of the SANDF, the SAPS, and any other enforcement agency or officer. Now, we read that to mean that independent bodies that can exercise oversight functions over the SANDF and the SAPS, meaning IPIT or the Ombuds or Parliament or Human Rights Commission. But we can create the guidelines for those institutions which they say are not even independent enough. Now they say we must determine their guidelines about where complaints must be lodged. We submit that's wrong-headed, that order can't be granted, my lord. So those are the guidelines at 4.2 to 4.25. No order can be granted in relation to those guidelines, but there's still...
I just want to make a note, which minister is it that makes all these rules?
It's the 10th respondent. The 10th respondent is Minister of Cooperative Governance and Traditional Affairs. Yeah. So they joined the minister and say in their affidavit they seek no relief against this minister. But they want us to produce guidelines that minister should produce and tell them how we're going to enforce them.
Yes, I was wondering, anyway.
Yes. Then, my lord, I don't have to deal with paragraph 5. My lord, they've dropped paragraph 6, but they retain paragraph 5. My lord, again, you will see that they also want mechanisms sorry, so 5.1 and 5.2 I think are still relevant because they're still in the draft order.
What do you say about briefly 5.1 and 5.2?
Number 5.1 and 5.2 again, these are independent bodies that must investigate. How do we create the freely accessible mechanisms for civilians to report allegations against the SANDF, the SAPS or MPD? If they're saying that the existing mechanisms of the IPID and the OMBAT are not sufficient, they must challenge the statutory framework that establishes those so that it can create more efficient mechanisms. But we can't now, as the executive who must be investigated, establish the mechanisms to complain about us. With respect.
Let me just ask you this. In 5.1,
Yes.
for argument's sake, there's a offence permitted by defence force member. An assault, for argument's sake.
Yes.
Where would that victim or his family go to complain?
So they would complain to the military ombuds. If they
would go to the
ombuds.
You know, they wouldn't know. You know, I think most people don't even know there's a military ombud.
But that's an issue for the military ombud, not for the minister
No,
of
but what I
defense.
mean, a person is now assaulted by the member of a defence force.
Yes.
And he doesn't know anything about the ombud. He now goes to, say, the nearest police station. And what will happen to you?
If he goes to lay a charge with the police.
Yes, he said, I was assaulted by the defence force. What will the police do?
The police has jurisdiction to investigate because they have...
So you won't be turned away and said, look, go and visit the ombuds's office?
No, they won't. They can lay... This is over and above laying criminal charges against the... Recall, my lord, that if it's crimes that fall within the military courts, you can go to the military police. But you can also go to the SAPS because Section 205(3) of the Constitution say the object of the police force is to investigate all crime. So you can go, you can lay, these are serious crimes, it's torture, but you can lay criminal charges against